like Camilo said, if Parliament has the power to proceed in making a determination as to whether or not the president failed to assent, and that bill can now be passed into law because Parliament proceeded to vote on it, then what is the point then? And how do we then arrive at that decision to say that the bill has expired because that Parliament has elapsed, its tenure of office has elapsed? So all the time and money and resources that people and energies that people factored into making that bill, just because one person failed to take a decision on it, does it amount to a no bill? And therefore, does it amount to a no law? We should, and this is what I'm saying, Kujo. So for instance, if it has been indicated in the standing orders, because first of all, the Constitution gives us some powers, but if the standing orders must also capture same, clearly, simplicity, to say that when the president fails to assent a bill, it does not lie in the mouth of the president to say that the bill is no bill and therefore cannot be assented into law. It should be brought back to Parliament for same to be voted on. And that it does not expire because that Parliament is no more. That is one. I think that we should be careful in always running to make political decisions to say, oh, at this point it's in my favor, so let me walk or run with it. We need to always think about the Ghanaian people first. Is the bill, if assented into law, or when assented into law, would it help the Ghanaian people more? Is it for the very good of Ghana, or is not the best decision that one may have taken? If we are taking decisions based on only what one wants to do or say, we would always come back and end up in the courts. Because I know and I foresee, and you may think otherwise, but if I were in the majority, one of the things I would do with this bill is to send somebody to go to court. And that is going to really be an action. And the action may more like restrain any further deliberation on this matter. Because mind you, when Camilo was making the presentation, he even went to the extent to say that when matters are sent to court, you are not bound to comment further on same. But we are going to have, there is supposed to be a platform for the Chief Justice who has been appointed to be vetted. Vetting, easy comment. Are we going to look at interpretation and other sections and say that, oh, when you are vetting someone, does that amount to commenting?
Or will a report be taken to the
floor? For comments to be made on that?
Which report will require members to comment?
So these are the major issues. And just before I go, for instance, under the issue of Article, is it 106.13? On the issue of certificate of urgency. You and I know that it's been abused left, right, center. For instance, and these comments are apolitical, really. That, for instance, Gold Board. You and I are now asking and finding out where their sources of funding is. Meanwhile, we passed it. Although we're virtually sacked from being a part of the process. It's been passed. And the directive or the instruction on it is that it was passed by Parliament. What is happening to it? But if the Ghana Medical Trust Fund or whatever, we've passed it. Also under certificate of emergency or agency. Yes, but we have national health insurance. These are major issues that we would have gone ahead to solicit for some ideas and views from stakeholders to find out, okay, does it make sense to also is it reasonable to still have the Ghana Medical Trust Fund? Really? And if you're saying that, oh, that takes care of some high-risk diseases, can that not be under national health insurance? Basically, and so this is what we are doing.
Okay, when a bill is sent to the president to assent and he's not working on it, is it a political bill? Or is it a bill for the nation? Because if it's a bill for the nation, have we done due diligence to it? Have we done stakeholders meeting? Is it going to favor Ghanaians or a particular party? And if there is change of government, does it mean we should throw away all the work that we have done? Because we have done a lot of work, committee work, joint committee and other stakeholders engagement. Now, if there is a change of government, what I expect is the government to look through if there is something that we need to change, then maybe they can refer it to Parliament. Then we do the slight changes, then he assent to it. But if the first government didn't assent to it, what are the reasons? Maybe that is what would delay the bill, because they have to consult them again to find out reasons why you didn't want to assent to it. And then this new government should look into it to see if it will do some additions or subtractions. Bring it, we work on it. Then we send it back for the current president to. So it shouldn't be something that we should cancel totally and start from scratch. That one will not help us because it will cause financial loss to the state. Yeah. So we should look at it from a level that the president now should just do slight. Maybe if you want to even own the bill, it should just tell us that I will own the bill, and so do those changes because now I'm the government in charge and I'm going to assent to it. If the previous one didn't, then who should owe it? I should owe it, and then make sure we pass it. So I feel there should be a lot of engagement now with the executives and Parliament so that we can quickly pass it.
Thank you. I'm going to ask for some help to get the microphone across. I want to hear from Sena. And Sena, I want to hear you on whether or not the standing orders of Parliament are sui generis, or they should fall under Article 11(7). Doc, I also like to hear your reflection. Please be very quick on that one for me. And then, friends and colleagues, I will yield the microphone. You have questions or comments, just make it snappy. I just want to be, sui generis. It's of a kind of its own. It is of its own kind. Okay, so. Yeah. Just let me be a little bit politically mischievous. I'm declaring before I do it. So what I'm doing, when you're in opposition, you said that there's nothing wrong with the bill. It should be assented to by the president. And today you have 2/3 majority. Don't change one word, crying. Bring it. And then let's.
We will bring it. The president must see if it's okay.
It's okay, cry. There's nothing wrong with it. You should bring it. Don't change one word in it. Senna, let's hear you. Then let's hear Doc.
Respectfully, I believe the standing orders are sui generis, are of a kind of their own, and should not come under Article 11(7). I'm of the view that when I read Article 106, it says Parliament shall make laws by passing bills. It doesn't mention other subsidiary legislation. So I don't see how Parliament will practically pass the subsidiary legislation, which usually would have come by a minister signing the legislation. So in this case, is it the Speaker who will sign the legislation and delegate its lawmaking power to itself? Because subsidiary legislation, Article 11(7), is about delegation of power to a subordinate body to pass a law. So how can Parliament delegate its own lawmaking power to itself and then pass standing orders? So in my view, Article 110 was clear that Parliament shall regulate its matters by standing orders, and for me, that is what Parliament did. I'm also of the view that it's easier to amend if it is passed by resolution as it has been done. These are my views.
Doc, do you disagree with her in any way?
Indeed, I agree perfectly with her. Counter to my boss's. Because you see, we keep saying that Parliament is our masters of our own rules. So to be the masters of our own rules as loosely, then you don't want to bring rigidity into the rules so that when you want things to be done, you can just set aside the rules and do it. But if you come under Article 11, then it means you have to lay 21 days, and if you want to even amend aspect of it, you have to come back and go through the same process. So I think passing it through a resolution is
very well. This is where the lawyers say, I have nothing useful to add. So I want to pass the microphone across. I see a hand up here. If you have reflections, thoughts, questions, we have some final 15 minutes, and then we will wrap up on this. Please do well to introduce yourself to us while you make your comments. Let's make it snappy.
Yes, thank you, Mr. Moderator, Benjamin Techi and Tiedu. Esquire, alias Attorney General. Yes, and Head of Legislation Office. Yes, so I will want to take a view on the lapsing of bail question. Yes, I quite agree with your earlier comment that Parliament should be seen as a continuing institution, but I beg to differ respectfully. Article 1131
Dissolution of Parliament.
exactly tells you that Parliament will continue for 4 years from the first day it starts sitting, and then will stand dissolved. And you compare that one to Article 2, quite clearly establishing Parliament and vesting it with the power to make laws. So you put these two together and telling you that Parliament is not a continuous institution. It's given a 4-year mandate, and the powers to make law must be exercised within that 4 years. That is confirmed by the case of Richard Sky. Looking at, Attorney General is delivering. Okay, Richard Sky's case telling you that, you know, Parliament completing the legislative process is not the end of the journey. You will need an assent of the president before it is complete. So it's premature. That tells you that if a bill comes to Parliament and is not passed within 4 years, it lapses, it has no effect, and it has to be reintroduced. And that is supported by my boss's view that if the president exercises his power to revert the bill to Parliament for reconsideration, then which Parliament will have that authority? And I think that that is worth.
And that if the old Parliament doesn't do it, a new Parliament cannot do it.
Cannot, because the duration, the power, or the authority of that Parliament will have existed. Yes, but I also have a comment, if you may. I have so many comments, but let me deal with the issue of subsidiary legislation, because I have a book oncoming, very soon. Yes.
We shall send you an invoice for your advert. Let's be quick, please.
Yes. Talking about subsidiary legislation, and then whether members have adequate opportunity to examine it and exercise the power of annulment. I think that first, before instruments are laid in the House, they are gazetted before they are introduced. Then our attention was addressed to the fact that it has to follow laying. Now we gazette after laying. And it goes for gazette and reprinting and never comes back. So most of the time you find that they come to force before copies are even brought. And members are deprived of the opportunity of 21 city days, each giving them the opportunity to file a motion for annulment. Thank you.
Thank you very much. I'll take other comments or questions from others in the House. Sana, let me see if there are any others before I come back to you. Senior, I haven't heard from you, so please introduce yourself and let's hear from you. And while at that, if anybody also wants to give us a reflection, the current pre-laying modalities that we have, is it extensive enough to deal with the mischief in the negative resolution principle as it's now being practiced? If anybody wants to give us a reflection on that. Senior, please introduce yourself and let's hear you.
Good morning. I'm Adam Idrisu. This kind of orders, until today, I always held the view that it is proper that Parliament pass it by a resolution. It was right. But I just changed my mind. And my reasons are this. Article 11C of the Constitution indicates that any order, rule, regulation made by any person, it didn't give any exemption. So when you go to Article 110, where it talks about the signing orders, and you just oppose that with Article 157, that has to do with rules of court committee, which comes to the House and treated as a regulation, then we cannot be treating subsidiary legislation differently because of the person involved. After all, Article 11 says any person or authority. So I think the best is for us to come under Article 11.7. Let it go through 21 days. If Parliament so desires, it passes. Thank you.
Thank you very much for your reflection. Senna, let me give you the microphone now. And then if there are others, we'll take them before we wrap up.
So just a quick one on the issue of lapsing of bills. I just want to indicate that it is not, it's a convention that we have picked up, and we've had several government bills lapse because they were not assented to. It's not, I mean, the first experience is not the LGBTQ bill.
Yes, that's true.
And if I like the proposal that Madam Confordoyo made, if it is the intention of Parliament to ensure that some bills don't lapse, then we need to provide for that in the standing orders. In Australia, for example, financial bills don't lapse. That is clearly provided for in their standing orders. So we can consider if we want some bills that should not lapse, provided for in the standing orders. Thank you.
Thank you very much. The Constitution itself is a living organism. Lawmaking process is dynamic. So as we see these lacunas, then we find ways, especially if the courts are not tidying them up, we find ways to clean up. We have some 7 minutes. If there's any general question on the issue of standing orders and the legislative process, now is the time to raise it. There's a young man in suit here. Are you also becoming an esquire, or you are an esquire? Or you are an attorney general already? Okay. Kindly introduce yourself, sir.
My name is Fosu in the General's office. I have a slight question, just a simple question. We know private associations within the country, like the GFA, they have evolved over the years to take on a national character. We also know they make laws to regulate their activities. And in regulating their activities, they are regulating the whole block of the country as far as football is concerned. So the process they also go through to make their laws, which are enforceable by the courts, is different from the parliamentary legal process, legislative process. So in this case, how do we marry the two?
You can even extend it to political parties and other things that have their own constitutions, which are subject to interpretation of the courts. And the question then becomes, what process should they go by? Should they also go by this subsidiary legislation? I have an answer, but I'll leave it to some of the other colleagues who are here, because I'm only a moderator. Are there any other questions or comments? I have remembered my old days in radio. So even if I have an answer, I don't want to give it. Are there any other questions or comments? AJ, I'll come to you. I want to see if there are other voices. Yes, sir. Behind the lights, please step forward. Just about 3 minutes to go. So this is the last one we're taking.
Yes.
And then I'll take you as well.
Thank you.
Okay.
Please, my name is David from Parliamentary Proceedings. From Adadi's presentation, we got to know that there were some practices that are frustrating the activities of practice and procedure. Something like the filibustering, and I think it disturbs the activities of proceedings, because as he was saying, he said that they used to delay the activities of lawmaking process and maybe other ones. So I want to find out, have we accepted such things to be part of our system to continue maybe disturbing the procedure or proceedings, or are there any actions to be taken in order to resolve such kind of things?
Thank you very much. AG, very quickly, 30 seconds. Let me hear you, and then I'll come to the panelists to wrap up.
Yes, thank you. Yes, boss, thank you for the comprehensive presentation. Yes, on second reading, the debate on the principles, and then there will be a vote. That vote, the Constitution expands it to allow members to even reject a bill. Have we had an instance in the Fourth Republic where a bill has been rejected as second reading?
Camilo, while you're responding to that, deal with this issue of bodies of a national character and how they go about their lawmaking, just for the record. And then I think there was an impression that filibustering disturbs the process. I think that view should be exorcised. It is part of the process. So, let's see. Yes, there was a gentleman who I afforded an opportunity to. Very final one on this side. And then while at that, I'll start from Camilo. You respond and then give me your final comments as we wrap up.
All right, thank you. My name is Jimmy Jaffa with the Legal Cluster of Committees. My question stands from the masters of our own rules vis-a-vis the recent publication the media concerning absentees of members of parliament. If you look at Article 97(1)(c) of the 1992 Constitution, it says that a member of parliament shall vacate his seat if he is absent without permission from the speaker or is unable to offer a reasonable explanation to a parliament committee of privileges for 15 days of a meeting of parliament. If you compare that one to the provisions in Order 16, it mimics the same provision. So there are two schools of thought that Article 97(1)(c) did not provide whether the 15 days should be consecutive or it should be 15 days per se. So as an institution and one of the core mandates of Parliament to strengthen its representational role, what is your response? What interpretation will you give to Article 97(1)(c)? Thank you.
Okay. I'll leave the last one to Pierre to handle. Attorney General, not something that I'm aware of, that a bill has been rejected at the second reading. I haven't come across, but maybe there's one. I think the issue relating to filibustering has been responded to by the moderator, so I will not want to go there. It's part of the parliamentary traditions. And yesterday it was explained well for you to understand, especially if you're a whip and you are looking for your people and they are pushing you that the vote must be taken. You have to find a way of gathering people around and then before the vote is put. I recall under J.H. Mensah, he was debating on the budget when Sivakoli was going to Legon. He went to Legon and came back and he was still on his feet. It's part of it, so there's nothing wrong with that. The issue of regulations by other bodies, I think, unfortunately, currently the practice is that those regulations are not laid before Parliament. They don't come under Article 11.7. I haven't done the research to understand why that is the case, but I think maybe because they are, subsidiary legislation is normally enabled by an act of Parliament or by the Constitution. I think maybe because in their case that is not what happened. That is the reason why this thing is not coming before Parliament.
Your final comments.
Just to say a big thank you to you, our moderator. I know you've always been there for us, and we are most grateful that you found time again. We've disappointed you. I want to assure you that next time we'll try and do better. Thank you. And to our other members of Parliament, the whips who are here with us. Thank you very much.
Yes, so 97(1)(c), it says 15 days. So 15 days, my interpretation of 15 days will be cumulative, not consecutive, as in 15 days in a row, cumulatively. And then this issue of, it was in the media. I don't know if it was the General Department that gave the list to the media, because as far as I'm concerned, I don't know any member who's absented themselves. This meeting, today is probably what, the ninth sitting or the 10th?
No, it was the first one.
Yeah, but the question is, where did they get the list from? I don't know if Mr. Speaker authorized it. That's what I'm saying, that I know it is not from the General's office. So I would wonder where they got the list from. And my final comment, they do their own counting. Anyway, but the thing too is, the problem with that one is that, currently, if a member is at committee, the member is deemed to be within the precincts of Parliament. The member may not have answered to a roll call on the floor. The member may not have signed the attendance that goes on it. But at the end of the day, we get a list from committees department. I'm sure the General's office will attest to this. We get a list from committees department and some members were at committee. So on the face of it, it might look like the member was not on the floor, the member was not in the house, but the member may be at committee, and that constitutes attendance in the house. So final comments. Thank you all for coming. And I think, like my boss said, time. Thank you very much.
Thanks very much. Honorable Jerry Ahmed Shaib.
Yes, Mr. Moderator, thank you for the opportunity. I think so far we've had a very sound conversation. There are a few bits that we would have to reconsider. First of all, like the gentleman that just talked about absenteeism. So you're looking at 15 days. You now can hear Justice Ekia Somwa now making a whole interpretation of the law. So And this is why I think that for our standing orders, that's almost sacrosanct. We need to capture all of these things clearly to indicate whether or not 15 days means cumulatively or consecutively. All of that we would have to address. And really, I think that we should have more of such platforms so that some of us can also be educated on some of the things that are unknown to us. Because, I mean, on the issue of whether or not a bill lapses and then going to 97 and all of those, these are also matters of interpretation. And depending on where you are sitting or you're standing, that may sound favorable to you. So I think this is a good course and we should continuously pursue same.
Thank you very much. Justice Ekuya, as she then was, what?
A big one. Jerry, Order 16 was culled from Article 97 1C. So if the Constitution says 15 days, none of us can say cumulative or consecutive, unless the Constitution is amended, not the standard.
That's the point. So I agree with you.
You have a microphone.
Exactly.
Thank you. For the absenteeism, I think there is a lot of error that we need to correct, and we say that members, we cannot say members are absentee themselves. When they are in a committee meeting outside Accra, they cannot come and sign. That's especially when we have certificate of agency and they need to work on the issue immediately. They have to leave the premises and go and work on those things outside Accra. Then when they have been assigned to go and do international programs for the nation, the protocol officers, you know the number of MPs that are leaving the country this week. It's your duty to write to the table office that this number of MPs will not be available next week. We should correct all those things. I think we don't do those things. And then committee chairman, you know the people you are sending out of Accra to go and work in some of the bills for the nation. So when we close our eyes as if we don't know they are working outside the premises for us, then the whole nation or their constituency will see them as truly they are absent in the chamber. Now, people are taking advantage of the publication, which Parliament knows that is not true, that the people are absent in the chamber for doing nothing. How can you say a finance minister is absent and is not? He's working for the nation. So quickly, you should have come out, the table office should have come out and then counter those who don't understand our job. Those who are outside Parliament, they don't understand what we do here. So they give different interpretation while we know that what they are saying is not true. So please, table office and then protocol office, sit up and up your games. Let us have, even with the whips, we will start demanding it from the protocol office. How many MPs have you sent outside to go and do international work for the nation? Then the clerk to committees, you have to finish the office of the whips that this number of people are leaving Accra to go and work outside Parliament. So that all those things, the other people who don't understand our work will not contradict us, please.
Thank you very much.
How many MPs are here? Can I see by hand? How many MPs? Only, you see that we have only one MP. Mr. Camilo, you know why? You didn't do consultation for the time. Wait. You didn't do consultation for the time. Me, I was even smuggling here. I just came to observe what you are doing and you smuggle me here. Next time, do consultation because MP cannot come here 9 o'clock and leave 9 a.m. and leave here 7 p.m. at times 8, 9 p.m. So from 9 a.m. to 9 p.m., making it 13, 14 hours in Parliament. Meanwhile, we are not providing lunch for them.
So I want to start by thanking all our panelists and Mr. Camilo who did the presentation. I think it's a very good presentation. And for all of you who have contributed, I want to say a big thank you to you. I think that the exercise of continuous learning is one that we should be a bit more aggressive about. It's been very edifying for me and my colleagues who've been on it. And I think that for staff of the parliamentary service and then for members of parliament, sessions like this should be made a bit more regular. It's also important that we get the public to understand some of these things so that things will not be misinterpreted. People will have an understanding. For example, if somebody is filibustering or something, there will be an understanding within our media, CSO, and general public colleagues. There's also an obligation on members of parliament. If you will not be available, you are traveling or something, leave of absence is your responsibility to fill so that the table office will do the right thing. When we were in power, there were many times we were marked absent. You carried the cross, so you Section 2 of the Right to Information Act says that where government, big G, believes that some information will be necessary for public use, don't wait for somebody to request publish it. It's obvious now that attendance of MPs is of interest to the public. So Parliament should consider tidying up the records and perhaps even publishing so that the public knows whether your MP is attending or is not attending. It will avoid all of these things that are ongoing. And then the last thing I would say is that let us have better respect for time if we want our productivity to improve. I want to thank you for the opportunity to have been with you. Thank you. All the best. Justice Secretary.
It has been a very insightful discussion, and I believe our moderator, discussants, and all of us deserve a resounding applause. Let me acknowledge the presence of Honorable Patrick Boama, MP Okakwe Central. We will now take a 15-minute break to come back at 12:20 for the third session. Thank you.
Then the Constitution and the standing orders also mandate and give committees some powers. We usually see that, members say that, committees have the powers of a high court. But the powers of a high court is in relation to these three things. That is enforcement of attendance of witnesses, the production of documents, and then taking evidence on oath. Basically, three types of committees. We know standing committees, select committees, special or ad hoc committees. So normally, the standing committees deal with matters relating to Parliament's day-to-day activities, for instance. So you have the House Committee,
the conduct of parliamentary business, for instance, the business committee, the privileges of the House, rules and procedure, and other constitutional obligations. So these are the list of committees. Yes, the new standing orders created, now we have about 44 committees from 31 under the old standing orders. New committees have been created to ensure that the operations of committees are enhanced. So for instance, the former finance committee has been restructured into 3. You have the budget committee, the economy and development committee, and then the finance committee itself. So select committees are created, established to also oversee the government. So each government ministry has its corresponding committees in the House. Right, so in cases where issues come to the House and the matters does not fall under any committee's jurisdiction, ad hoc committees are created to take care of that. So there have been a couple of ad hoc committees established by the Parliament. I can think of the committee on the essential motion of the Finance Minister, which I served with Mr. Camilo. There is also the bribery allegation committee that was set up. A committee was set up to investigate the banking crisis. These are all ad hoc committees. So as I said, we have 44 committees in total. The average size of a committee is 17. And the composition must reflect the differences of opinion. And every member shall be appointed to at least 1 committee. Right. Selection of chairperson. So under the old standing orders, we realized that only 2 committees were chaired by members of the opposition. But the new standing orders recognize that to ensure accountability, then some committees should be chaired by the opposition. So we realize that most of the accountability committees are now chaired by the opposition. So the new standing orders says that the following committees will automatically be chaired by a member of the government. So the Finance Committee, the Foreign Affairs Committee, the Defense and Interior Committee, Security and Intelligence, Employment, Labor Relations and Pensions, and then Constitutional Legal. These are committees that will automatically be chaired by members of the majority. Then the minority will chair the following committees automatically: Budget, Committee on Public Administration and State Interest, and then Public Accounts Committee, Subsidiary Legislation. However, the rest of the committees will be chaired based on the proportion of seats won by the parties in the Parliament. If we look at the leadership structure of committees, we have the chairperson, vice chairperson, ranking member, deputy ranking member, and the clerk to the committee. In the old standing orders, it did not provide for the duties of a chair of a committee, which normally creates a number of challenges in the execution of committee's mandate. So now in the new standing orders, clearly it has spelled out the duty of the chairperson and the clerk to the committee. So chairpersons are supposed to preside over the committee meeting, act as the official spokesperson of the committee. They promote consensus, protect and preserve the right of members, maintain order at meetings, and then decide on questions of order where a person persists in disorderly conduct. Yes. If you look at it, the standing orders did not provide for
the duties of a ranking member. But by observation, we realize that the ranking members also perform an important role in the management of committees. So they are the leader and spokespersons of the side that does not chair the committee, right? And they collaborate with the chairperson to plan the activities and agenda of the committee. If the committee will perform inquiries or public hearing, they agree on the witnesses and also determine the direction the inquiry should go. The ranking member, they analyze bills and proposals and highlight the implications, alternative views, and any minority concerns into the report. So at times we see that when committee reports are prepared, the minority will say that, yes, we are not in favor of the report. We want to present an alternative view. But there is this view about minority report. But the rules does not provide for a minority report. So if you have issues, concerns to be raised in the committee report, you have to present that issue and it must be contained in the same report of the committee, right? And then the ranking member on the committee also coordinates the work of his side and ensure attendance at meetings. Then another critical officer on the committee is the clerk to the committee. So the standing order says that the clerk to parliament will appoint an officer to be a clerk, to serve as a clerk to the committee. And their duties have been provided in the standing orders. So they head the secretariat of all the committees. They provide procedural and technical advice. They transmit memos of meetings, record meetings of attendance, amendment, and all that. So these are the duties specifically provided for the clerk to the committee, and they are supposed to do this in consultation with the chairperson. So normally they administer oath. So during the public hearings, you see the clerk administering the oath they swear in the witnesses. They are responsible for divisions in the committee. They can issue sermons when witnesses are invited to committees and they refuse to attend. They are also supposed to submit proposals for the strategic plan and work plan containing the programs and activities and the budget of committees. And now this is a bit of a new function to committees, and as we go on, you see that there is a committee called the Committee on Ways and Means that are supposed to scrutinize the work plans of what all committees submitted by the clerk. So let's look at meetings of committees. So when committees are constituted, one of the operational things they do is to meet. And meetings of committees are governed by Order 266. It is the responsibility of the chairperson to summon a meeting. Right. So the chairperson will summon a meeting, and usually the clerk will issue the notices to members to attend the meeting. Now, our standing orders provide that all committee sittings now must be in public, except otherwise what? Provided that they must sit in camera by the committee. And there is this new provision that 15% of members of a committee may request a meeting of the committee. This provision was introduced because we realized that if you have a chairperson who has the authority, sole authority to call for the meetings, and he is not calling for meetings, it will create problems. So we realized that in the last parliament, the finance committee was expected to consider some waiver of taxes that were introduced. The chairperson then refused to call for meetings to consider those tax waivers. And
those tax waivers were pending before committees for a very long time. For over 2 years, those waivers were still pending. And our rules state that if a matter is referred to a committee, the committee has about 3 months to work on it and then present its report. And under the old standing orders, nobody could compel the chairperson to call for a meeting. So this provision has been introduced into the new standing orders, so that if the chairman refuses to call for meetings, 15% of the members of the committee can then compel the chairperson to call for meeting. And within 7 days, the meeting should be called. This provision is copied from the House. Like, the Constitution also provides that 15% of members can call for Parliament to what? Sit, to be constituted. So, this provision has been transposed to committees for committees to work effectively. Because now, the idea is that you have some committees chaired by the opposition or minority. So if they want to, let's say, disrupt government business and they are not calling for meetings, this can help to let them call for meetings. So quorum. At committees, one of the key challenges is quorum, getting quorum for committee meetings. And it is said that 1/3 of the membership of the committee constitute what? A quorum. So if you have a committee of average size of 17 members, the quorum should be what? 1/3. And we realize that because members belong to multiple committees, at times it becomes very difficult to get quorum. They will come, sign the attendance register, and then will leave for another meeting. And when they leave, you see that the quorum will dwindle. And what do you do? Do you continue with the meeting and all that? So we had instances where you go and sit in a committee room, you wait for members, they will all come and sign. If another committee is meeting, they will just leave. And so quorum is another issue that affects committee. And there is the issue of absence of quorum, which has now been introduced into committees' business. So if any decision is taken at committees and they fall below the quorate number, which is 1/3, that decision cannot be taken. Then organization of business at committees. Committees determine their own agenda according to Order 266. And what is the agenda of committees? The agenda of committees normally is derived from the mandate given to committees under the standing orders. So if you take, let's say, Education Committee, their mandate is education matters, for instance. And they are supposed to derive their business from that mandate. So Education Committee, they have so many agencies under them, schools, ministries, education policies. These are some of the issues that will generate the business for them. And there's also another one on referrals from the House. Right? So committees derive their mandate also from referrals of the House. And also petitions and referrals from members of Parliament in those committees. So these are some of the business that committees deal with. So they consider bills, amendment to bills, private members' bill regulations, and all that. So all these matters here are referrals that are what? Automatically sent to one committee or the other. But another leg is that the committees on their own can also what? Generate an agenda. And that is one of the things that our committees are not really doing. They wait for referrals to be made to them. But rather, they should look at their mandate. If it is health, you can look at the issues at health and then do public inquiry. So when we get to the public hearing, you will see how they should go about it. Yes, so the standing orders provides that the committees can just decide and consider any matter that is within their mandate. You know, the old standing orders restricted committees. So normally they wait for referrals, but the new standing order says that they shouldn't wait for any referral. If within your mandate, which is education, matters come up, you can go ahead and investigate it and then issue a report. And then also, a committee to which a matter has been referred to should also report to the House before the end of each session. And if you look at the timelines of referrals, there are conflicting provisions in the standing orders that tends to limit the timelines of reporting. When Camilo presented, the deputy clerk indicated that when bills are introduced, so if you look at order, is it 178? Bills should not stay in committees for more than 3 months. But if you also come to order 267, right, it confirms that a matter which has been referred to a committee shall be reported on within 3 months. But if you go to order A2851, it also says that a committee to which a matter is referred shall refer to the House before the end of each sitting. Right? So, whilst one provision gives a session, the other provisions also restrict it to within 3 months. So, normally, committees will go under 2851 and say that they still can hold on to matters referred to them within a whole year. Right. Let's look at report of committees. So after all these committees must what? Produce reports. The deliberation and recommendation of the committee shall be presented to the House in a form of a report. And how do we go around generating our committee reports? So we realize that the old practice or the current practice is that committees We realize that the current practice is that committees, normally the clerk to the committee will generate a report and will send it to the chairperson and ranking member to look at. After looking at it, when they are okay, then the committee, they sign the report and it's sent to the floor. But there is an elaborate provision in the standing orders that must be followed. So if you look at Order 216. It says that a committee to which a matter has been referred to may generate a report. The report that will be generated by the clerk is a report of the chairperson. And that report must be placed before the entire committee for deliberation. Right? And the committee will look at the report, go through the report page by page, and then get amendment from members, and then say that the report is brought up by a member and be read a second time, paragraph by paragraph. So any member of the committee can also introduce a report, which shall be considered by the committee. So this is an elaborate procedure for consideration of committee's report. It is not like the clerk to the committee and the chairperson ranking member, when they agree and the report goes to the floor, then you see some members complaining that they've not even seen the report. Right. Let's look at public hearings. Now, the standard orders provide that committees meetings shall be held in public. How do we go around this? In the past, committee meetings are held in camera, so committees are at liberty to adapt their own procedures and then go without any accountability. But now, when committees sit and hold public hearings in public, it will open them up for public scrutiny. See, so parliamentary committees conduct public hearings as a key mechanism for engaging public, the experts, and stakeholders into the legislative process. And these public hearings promote transparency, accountability, and participatory democracy. So these are pictures of some of the committees having public hearings or public sitting. This is the appointment committee, PAC, and the rest. Yes, these are provided for in our orders. And normally, the objective for public hearing is for Parliament to gather expert and citizens' input on bills, policies, and issues before the committee, and to test the accuracy of evidence that are presented. So if, let's say, the committee receive evidence, they can test it through public hearing. It also helps promote transparency in the work of committees. So, for public hearing to be conducted, there are various stages of it. Right? So there is a preparatory stage. The preparatory stage is where the committee prepare and select the subject matter of the inquiry or the hearing. So, public hearing, as it allows the committee to, on its own initiative, pick matters and investigate and send reports to the House. So they select any matter of public interest, any public proposal. It can be a referral from the House. And then they will issue notice to the public, give a date when and venue for submission, specify the topic, date, venue, and submission deadline. They will set up a date for the hearing to take place. They will invite stakeholders, civil society groups, experts, and affected communities to attend the hearing. Then the conduct of the hearing itself, the chairperson will call the meeting, introduce members, outline the objectives. There will be questions and clarification. The public can observe. There will be presentation of and submissions of the evidence to the committee. Then the post-hearing is the documentation and reporting, and then follow-up and implementation. So the standard orders also provide for rules for public hearing. So admission of strangers in committees, engagement of experts, engagement of counsel, expenses of witnesses invited to be borne by the committee, examination on oaths and affirmation. Then after the evidence are gathered, normally we return the evidence to the witnesses for correction before we incorporate them in the report. Right. So basically, in all this, the application of the standing orders generally must be at the back of our mind when we are managing committees. So, for instance, we saw that Article 1123 regarding the 15% members can recall a meeting is now reflected in committees, which is a general application deriving from the plenary. So, at committees, we expect that portions of the standing orders as much as possible should guide our work. So we can talk of Order 53, Order 53, which regulates the order of business. So you have record of attendance, leave of absence, order of business, Order 67, prayers and roll call. All these are some of the things that we can adapt at committees to regulate the committee's business. So let's look at administrative support. Committees are grouped into clusters. So you have PAC, SACs, and ACs supporting committees. Official reporters are the research officers, experts, and consultants. The service is also in the process of creating the fiscal analysis office, budget office, and then policy analysis office to support the work of committees. The role of Ways and Means Committee, as provided for by Order 232, is also to coordinate the work of committees. Committees must develop work plans and submit it to the Ways and Means Committee. They allocate funds for them to, but this has not really been operationalized. So once it's operationalized, the Ways and Means Committee will be the main committee that will allocate resources and ensure that committees work effectively. Right, let's look at some of the challenges facing committee operations. So, inadequate technical and research support. We all know that our committees lack the research support required. So if you look at finance cluster, for instance, all the finance committees are there, but how many research officers do they have? How many experts do they have to help the committees do their work? One key thing is the enforcement of recommendations of committees. If you look at the standing orders critically on the operations of committees, there is no order that support committees to enforce the recommendations of their report. You can take the Public Account Committee, for instance, right? The select committees does not have anything. So when they issue their report and the recommendations, resolutions are passed and it ends up at that level. Nothing happens. So this is one of the key things. And also when committee on its own embark on an inquiry, for instance, if the House does not grant it space to lay its report, the report will be there and then nothing will happen. So for instance, the Social Welfare and Employment Committee, we did some investigations into state-owned enterprises. We submitted the report. The report was not taken. Nothing happened. In some jurisdictions, committees are allowed to publish the investigations they do without recourse to the House. There is also limited public engagement. The committees do not engage the public on critical matters. So when referrals come, it's on few occasions you hear committees meeting public and getting their views into the processes. So, and this is as a result of the fact that there is no rule or formal procedure for engaging parliamentary committees provided for in the orders. It is left at the discretion of the committees to see whether they will engage the public or not. Then insufficient time for scrutiny, the increasing use of certificate of urgency and setting aside the rules also affect how committee work. So there is a need to strengthen the research and analytical capacity within committees and institutionalizing regular follow-up on committee recommendations. So we can set up a committee to follow up on these committee recommendations. make sure that some of these recommendations are implemented. So, in conclusion, parliamentary committees are the backbone for parliamentary effectiveness. Although they face various challenges in their operation, we think that with the needed support, they can improve on their mandate and help Parliament achieve its goal. Thank you very much.
Thank you very much. Thank you very much, Dr. Dafoe. I know you would agree with me that he has actually educated us more. We all have the standing orders, but listening to him this afternoon, I'm sure you've picked one thing or the other. I want to thank you for that elucidation. I want to once again share with us the vision of Parliament. The vision of Parliament of Ghana. We said we want to be a model parliament that secures for its citizens the blessings of liberty, equality of opportunity, and prosperity. Isn't it? And Doug has mentioned a number of challenges we are already facing. And so I'd want to invite our panelists at this time to just give us a few remarks. They've all listened to the presentation. I have a few questions I'm going to put that we can all discuss, including you sitting there. It's going to be interactive. But before we proceed with that, I want to invite Honorable Boama to share a few remarks on the presentation that has been given before we proceed to the questions. Thank you.
Thank you. Thank you, Gifty, and good afternoon.
Good afternoon.
Dr. Dafoe, thank you for your wonderful presentation. My brother, Minka, how are you? Gifty is ready to fire some questions, but let me commend Dr. Dafoe for his presentation. He touched on a lot of things that most of us will overlook when reading the standing orders. As practitioners of the rules of the House, we need to always be abreast with what the standing orders say and the Constitution. Doctor, in your presentation, I think in looking at the committees, you overlooked the Committee of the Whole as a very important committee that sits in closed doors to discuss some matters affecting the House and the country. I also noted that there's a lot you could have said in your presentation. You could have taken a whole day or 2 days to digest the work of the committee, especially looking at the committees from Order 204 to 285 on division, on votes, and original vote, casting vote by the chair, what have you. But I was very impressed with how detailed you were with regards to the duties of the chairperson of the committees, the clerks, and the very important staff that helps the committee. This parliament has, under the Fourth Republic, we've seen or gone through a lot of ad hoc committees. And I was happy you mentioned a few of them, but the Cash for Seats committee and a few others that were very controversial. But all in all, it's a very good presentation that you've delivered. And I believe the questions will enable us to throw more light and practicalize some of the things that you've presented to us this afternoon. Thank you very much.
Thank you very much, Honorable Boama. Let's give it up for him, please. Yes, yes. And so, my dear colleague, you would also want to share a few remarks with us.
Yeah, thank you very much, Gifty. Let me also add my voice in thanking Dr. and Stafo for such insightful and very comprehensive presentation. In fact, he has touched on all the issues. Just as my co-panelist said, I think time did not allow him to go through into details. What I want to, my initial maybe comment, I want to comment on the enforcement of committee recommendation. The current strategic plan that we are doing, Doc is a member of the technical team. It came out very, very strongly as what can we do to be able to follow up on recommendations of committees. So we have it as a very key initiative in our current strategic plan. And we have a number of strategic actions that we have teased out that we are going to deal with it. So I'm hoping that by next year, when we roll it out, we'll be able to overcome these challenges that as committee, class, and as parliament that we are so much concerned about. And then one other thing maybe I also want to react before Gifty will come up with your question. It's about how we get citizens to participate in the work that we do as members of parliament, What we noted when we were doing the stakeholder analysis and we were doing the SWOT analysis for our current strategic plan is a limited use of technology, because parliament or committees cannot be everywhere. So how do we leverage on technology to be able to get citizens to participate regardless of wherever they are? And that has also featured very, very strongly in our plan. So just to give a teaser of it, that when we roll out next year, we will be able to overcome some of these teaching challenges that we are currently facing. So, Gifty, maybe your questions will help us to throw more light.
Thank you very much, Mr. Mika. Thank you. Thank you very much. Colleagues, we are mindful of the time that Chamber will start. And so, as we give out the questions, I want us to be brief. And if you are participating, just briefly introduce yourself and then you contribute. So let's go quickly to committee operations and procedure. Doctor has thrown a lot of light, but I want to ask from all of us, not only the panelists, but we start with them, how do committees balance the need for efficient decision-making and the need for thorough scrutiny and oversight? Doctor has mentioned some of the limitations we have faced over the years. But then, in the midst of it, we're trying our best. What can we do better? What do we think we can add on to make our scrutiny and oversight role that we play more touchy, more sane? I'll start with Honorable Boama.
Thank you very much, Gifty. I think, first of all, there's a need for committees to be assigned the right expertise, especially when a technical referral is made to the committee. Doctor mentioned the banking sector crisis and the referral. You can be an MP, a clerk with all the degrees or whatever, but when it comes to certain specific or technical areas, the committee ought to be assigned a very technical person to assist the committee. Question now is Parliament ready to fund the appointment of such a person to assist with the committee work? And will Parliament be willing and able to provide the necessaries or the requirement that the committee needs when it comes to the appointment of such a person to assist the committee? Is something that we must consider? Or will Parliament I saw on the presentation that you were looking at financial analyst, budget analyst. Will Parliament consider recruiting permanent analysts or resource persons to be available 24/7 to committees when they are needed? It's something worth considering to help with the effective implementation of committee work. Thank you.
Very much, Honorable Bama, and I think I must add permanent and independent analysts, people who would be able to profile, the rightful thoughts based on data, based on evidence. That is what we should be looking at, isn't it? Mr. Mika, I want to take your thoughts on that.
Yeah, thank you. I think Dr. hit the nail on the right side. Technical expertise support to committees is really a challenge. Besides the suggestion that he has made, I think that we should rather leverage on the existing institutions. So we need to enter into some kind of strategic partnership with the research institutions that we have, so that we can institutionalize some kind of information sharing sessions, being quarterly, being semi-annually, so that relevant committees will engage their respective academia, think tanks, and research institutions to share knowledge in their research finding. And then the other challenge that Affairs Committee also has to do with funding. Funding. How can we, in the midst of the limited fiscal space that we are facing, how do we mobilize enough funding to be able to embark on our oversight activities? And I think we need to explore more with our development partners, and again also to link out with CSOs who are already on the field, so that we can collaborate with them in furtherance of the exercise of the mandate of Parliament, or committees specifically. Thank you.
Very much, Mr. Minka. And so this brings me to the critical officer. Today, I got to know that I'm a critical officer as a clerk to a committee, because I tend to manage. I do the work plan, budgets, I'm a spending officer, I'm a reporting officer. So I'm the engine room, isn't it? So we are the engine room. So let's see, these officers who manage and administer committees, they provide procedural guidance to members of Parliament. What can be done to support their work such that as we find it, we'll be able to churn out even some of these expert reports, liaising with the existing institution, and make our work better? 30 years on as the Fourth Republic, 9th Parliament on, what can we do better in the coming years? Mr. Minka, what do you want to start with us? Thank you.
Thank you very much, Gifty. I cannot agree with you what you said as committee class. I always say that committee is good as the clerk, because just as Doctor said, you are managing the members, looking at their competing priorities and their needs. So, first of all, you need to understand your terrain very well. When you are assigned to any committee, what you need to first understand, read every legislation that relates to that committee, so that you really understand the mandate of the committee very well. And then with that, you also look at the relevant CSOs and the think tanks that also work within the area. I want to share a personal experience with you. I handle Mines and Energy Committee, and my members thought I was an energy expert, but I was relying on African Energy Africans Center, yeah, especially Ben. When I ever encounter any difficulty, I just reach out to them. I have a number of think tanks. When the technical issues, I reach out to them, and then they make it my work so easier. So my advice to my colleagues is that, first of all, read all the legislation that relates to your area of operation, and then secondly, look for the experts which are already working in the area, including those in the academia, and have that kind of personal relationship with them that you can reach out to them at any time. And that will make you on top of your job. Because remember, you are supposed to be a principal advisor to the committee. Meanwhile, you are a generalist. You are not an expert. So you need to innovate so that you can be on top of your job. Thank you.
Thank you, Mr. Minka. Honorable Boama, we work with you as a member of parliament. We are the critical officers that throw lights and make your plans as a committee member or as a chair happen. We are the background helping you to come out with a shine. On the floor, when members come out, read their statement, and they are on top, yes, nobody knows the engine behind, but that is our work. I want you to throw lights. What do you think we can do better so that we can help you shine better out there in our work? Thank you.
Are we not shining already? Anyway, thank you, Gifty. Let me tell you, the clerks, the kind of work you do, you must be very close to the clerks to understand the level of input or support you give to members of parliament. Just that they cannot speak on the floor to address some of the challenges they go through. First of all, there has to be a very organized capacity building program for clerks and your team, be it a table or any other committee or set up within Parliament. Gifty, I don't know how well funded your secretariat is. We go through a lot during vetting of nominees at the appointments committee. But I think there has to be some other attachment programs for some of the clerks to work closely with some committees or related committees in other civilized jurisdictions. And as a clerk, you also have to be dynamic and innovative. Lately, I see that you work in clusters. You can be in the legal cluster today, and the next time you'll be in the infrastructure or whichever cluster. So you need to be speaking amongst yourselves to understand that I could be in the next cluster, in the next meeting. And you must read a lot. Don't think you are working as the committee clerk for the appointments committee, so you have no interest knowing the happenings on the floor and also the happenings in other clusters. You need to, because next time when you are called upon, you find yourself wanting and you really want to be in that position. You need to be very innovative. You need to have relationships in other parliaments. And your work must be unique and be distinct from others. You have to show that you have a different style of working. And members will easily appreciate, the speaker will know from the memos you send, your work plan, the kind of reports you generate. When I pick your report and I read, I know you've done cut and paste, because I'll know that, oh, the following members were in attendance. We consulted the Constitution, article this, and standing orders, and other relevant legislation. You know that there's always a standard page 1 or 2. Must it be the case? You understand? Let us see something different. Let us see something different.
Thank you, Honorable Boama. Let's give it up for him. So I guess Innovation is what it's calling for. Innovation. We must be innovative in our words. Now, as I keep saying, we are mindful of the time that chamber will start. So I want to throw this quickly to fellow colleagues from what the ongoing conversation has been. If you have any question, the floor is open. Any addition, the floor is open. This side, one. Yes. So 1, 2, Madam Equia, 2. This side, 3, Edith. And then Dr. Anand, 4. All right.
Honorable is going, so let me ask
we will
my
take,
question.
we will take 2, we'll respond, then we take the other 2 and respond.
Yeah.
Mention your name quickly.
Okay,
and
my
brief.
name is John Tulu. No, so this one, I'm sure you'll be in a better position to give clarity to it. We've been told that the class of the committee provides procedural and technical support to the committee. In actual fact, you just mentioned that there's a new room to the committee. What we realized is that after the committee report has been prepared, those days we always, at the end of its recommendation, the report was adopted by consensus. In an extreme case, we see by majority decision. But now what is happening is that it's like consensus is not built at the committee level after the deliberation is done. When it gets to plenary, that is where, after the discussion, a group will go outside and now present minority report. And I want to find out, since the clerk to the committee provides these procedural and technical advice, whose duty is it to protect us, to ensure that at the committee level before the report gets to plenary, something is done to manage it in such a way that whatever view that maybe somebody may not be in agreement with what is contained in the report could be handled at that level and be part of the report before it goes. Because most of the time when they go out, the complaint has always been that minority views or whatever view has not been taken on board and it's not reflected in the report before it goes to plenary. So
very much, Mr. Tolu, thank you. So how to capture divergent view? Madam Equia. Honorable member, please, let's take the 2, then we respond quickly.
Kind of the first 2 pages, we try as much as possible to have a standardized report. That's the policy in our division, that at least the first 2 pages must be. The variations will come with regard to the background and then the observation, and so bear with us when you see the standard with regard to the introduction. That's the policy that we try to put in place, so that when you see a committee report, you see that this is coming from Parliament. We don't want different people doing different things. Also, my issue is, I agree with the need for experts and technical support for the committees, because it's more needed now that the committees are going to sit in public, because the recent things going on some of the committees who sit public indicate that we need experts to even tease out the questions for the members, help them with their the follow-up questions, because what happens on television is not really you sit behind and you realize that this is coming from Parliament. So the experts and technical support is really, really needed to help with the public, the hearings now.
Thank you very much, my senior PAC. We are grateful for that suggestion.
Let me take it up from where you ended. Your work is very difficult. We understand. As politicians, every politician goes on a committee that is live to settle some political score or win some public sympathy. Let me tell you, even if you set the questions up for them, they will change it they will ask their own questions and their follow-up questions. So don't lose sleep over what is happening on the screen. I'm telling you, I'm one of them. That's not my style, but I'm saying I'm a politician. But I take time to research and frame my questions. But somebody will come prepared, questions forwarded to him by somebody with an interest in a matter under discussion. And the person will fire, boom, and I know how you feel. So leave it to the politicians, let them ask their questions on TV, let the public view the person in the kind of way the public wants to see that person. It shouldn't be your headache. You are not the one asking the questions. Who cares? Do we care? Yeah, but you haven't contested an election. You haven't. As for you, you are doing a professional work. Yours is not to take sides. Let a person go and embarrass himself or herself. That's not your business. At the end of the day, the person will be called by his or her party and be told that, oh, question now, what friction? Meanwhile, you will be worried about the kind of question the person asks. Anyway, your question. Gifty has been with us and has gone through a lot on the appointments committee. Your work as a clerk is to produce what happened at the committee and have a discussion with your chair and your ranking member. Per our rules under 26, I think 2682, it reads that the chairperson shall promote consensus on matters under consideration at the committee. So it's the responsibility of the chairperson to use his or her skill to promote consensus, failing which the other processes can be triggered, votes, division, and what have you. There is nothing like a minority report. It should not be entertained. The rules govern the House, and we must be practitioners of the rules. If the report is generated and you have a view, let it be captured in the report. Because the referral, be it to the appointments committee or any committee, is a referral from the House, for which a report must be generated and sent back for a debate and a decision. So, clerks, please, don't fall into traps. Work with the rules. Produce your report. Have it signed. Bring it to the floor for us to misbehave, in quote. Yeah? That is your work. Once you get your report signed, let your chairman go and face the plenary. Okay.
Very well.
I believe that is how it's supposed to be.
Yes, yes.
I'm supposed to be chairing the subsidiary.
The subsidiary, so...
It's supposed to have started at 1. You were all late.
Yes, yes.
With your snack for 30 minutes.
Honorable, we are very, very grateful you are here with us, but just give us 10 minutes to all be done. Yes, respectfully. No, 10 is 10. Kofi, 1 minute.
Yes, 1 minute.
Thank you.
I think, colleagues, what we have not been doing well as committee clerks is to subject our report to Order 283, which details out how a report of committee should be adopted. Because normally it has to be adopted by the whole committee, but hardly do we meet as a committee to adopt the report. When we do the report, it's given to the chairperson and then the ranking. And sometimes you have an issue. even after the ranking has looked at it, chairman can come and tell you that take this one out. And the report is more or less, as you know, the chairman's report. So the provision under 283, that's what I want to encourage my colleagues to always subject the report through that process, so that once it's adopted by the committee and it go on the floor of Parliament as committee clerk, then you are insulated from whatever happened because it's adopted by the entire committee.
Thank you very much. Thank you very much, Mr. Maker. And on this point, I want to mention that colleagues who are not clerks, please don't feel left out because you are part of the engine room. Without you, the committees don't succeed. So please, whatever is coming out is going to all of us. What role can we also play to make sure that we draw attention to our class, we guide the process, and make sure we are all on the right path? Dr. Adam, please. Briefly, I promise Honorable Bama 10 minutes. So.
Yeah, I think mine has to do with experts, assistance to committees. The presumption is that when parliamentary service staff are employed, they are expected to provide technical and procedural support. So, for instance, you employ somebody, the state has employed you. The MPs who come to parliament, they are not experts, like Honorable Obama said. They are always in transition. You are supposed to be here for the rest. So this goes to PTI. And also people come to this institution not as experts. They might have studied various, but you should see that Parliament encompasses every discipline, from archaeology to zoology. So definitely when people are put on committees as clerks, apart from the administrative work that they are doing, they are expected to provide technical. So like Minta said, the moment you are deployed, it's your responsibility or the responsibility of the supervisor in tandem with PTI to capacitate this basic, so that your report should not be just an ordinary report. You must guide the committee in terms of the subject area. So at the end of the day, the report that will come will not be of quality. That's my only comment.
Thank you so much, Dr. Anan. I think Edith also wants to add a word briefly. That will be the last session for, the deputy clerk is here. Edith, 30 seconds. 30 seconds.
My name is Edith Omachele, and my question goes to Dr. Dafo. When he was doing his presentation, he said committees can take up things that are in public domain. So I want to know if a committee can just, maybe there's a matter of public interest, a committee is aware, know that it is its subject area. Can the committee take it when it hasn't even come to their house?
Okay. Dr. Dafo. Let's take
this one is particularly going to you.
Then you add it. Thank you.
I think the last parliament, for the first time, we had an instance where we had co-chairs of a committee. And I know you were an active member of that committee. I don't know if you can just share your experience and whether you recommend that type too as we move on. The committee on the Senator motion, where we had co-chairs of a committee.
Thank you, Deputy Clerk.
So, when the referral was made, I think the Speaker said he was appointing James Agaga and Atacha as co-chair, chair and co-chair. And it was a very, very sensitive matter that we're going to handle. So I think that was where the mistake came from. We never found or saw peace on the committee, to the extent that I don't know what became of our report. It was a very difficult period for the clerks and those working with us. So the rules are quite clear. There has to be one chair, and there has to be an odd number committee at every point in time. Recently, we were on a committee of about 8, and I wasn't very comfortable with it. We have to have an odd number committee where the chairman will have an original vote and not a casting vote by the rules. Who else? The lady asked Dr.
So you look at Order 267, which says that the committee has liberty to investigate any matter within its mandate. So if there is an issue in the public domain, you can investigate it, conduct public hearing, and then it can be done. But that is what I said, that committees rather wait for referrals to come to them before they act. But there are so many things they can do out there with that mandate.
My dear, when MPs want to be mischievous, from the question you asked, they will always come with a newspaper and say that, oh, Mr. Speaker, I rise to bring to your attention a matter of urgent public interest. But meanwhile, the person is a member of a committee. He could have originated a discussion at the committee. But that person wants the country to hear that there is some nameless attack on some security personnel at FIDIM or somewhere. They've mentioned the name of 2 MPs. Yes, they want to play politics. I just sent a message to my committee platform that we're going to discuss our agenda for this meeting. And I'm saying that we should consider, as a committee, a public hearing on some of the most important regulations that this House has passed. That is something that I want to do, because subsidiary legislation, we come, we sit, we look at the regulation, go through pre-laying, have it laid, it attains the 21 sitting days, and that's the end. I want us to take about 10 very important regulations, DBLA, mining regulations, finance regulations, insolvency, and look at how they are being implemented. And that is what I ferry to them, but I'm told the meeting is over, so I'll also take leave of you to go and see my ranking and discuss some other matters.
Thank you, Honorable Member. But
Thank you.
take note that we will report on this meeting, and so your concerns will be captured and will be carried on
Thank you
when
very
your
much.
members read reports of this. So,
Thank you.
colleagues, our time is far gone, but in my preparation, there are a few things I put on paper which we couldn't mention, and I just want to re-echo them to us. That is the challenge of our quorum. We see 17 members in committee, but then we haven't challenged of them rushing to other committees. So one of the things I put on the banner is, can we relook at the number of committee, looking at the ratio of 276 is to 14 committees. It gives us at least 6-member committee for each committee, so we can relook at it and reduce the numbers. Then we get members' attention at committee level. Number 2, in Dr. Dafoe's presentation, he mentioned that we didn't capture anything in the standing orders for duties of ranking member. It's something we can look at. The third one, challenges of quorum and absence of quorum. I've mentioned all that. The public hearing, that is the challenge that has been thrown to us. So in the coming year, our work plans, we've submitted them, but we can still make amends. We can challenge ourselves to take 1 or 2 topical issues, discuss with our leadership, and as Honorable Bama said, put up something. Our people are looking up to us because we are the engine rooms to their representation, and they want to see what we do. Our challenge as Parliament and as committees and as LMS, is our inability to have control over our budget and our funds. So we are actually restricted. We can't do a lot of things, but if we have adequate funding, we'll be able to do more. Now, the way forward, some of the things that have been recommended, and I'm happy our Deputy Clerk is here, our SPS is also here, that is capacity building for all officers of the institution. So PCI, this is a big challenge coming to you. We expect that you collaborate with other experts, technical officers, to build our capacity so that we can also work and be seen doing the right thing. And as Mr. Minka said, we should liaise, we should call out when we are faced with these areas that we don't have capacity in. People are there, they have data, they have evidence, they want to just share with us so that based on that, decisions can be made. Citizen engagement, the Citizen Bureau is there. We should reach out to them to help us close that loop, because we are here because of our people, so that they see us representing them fully. And then we should talk to each other. We shouldn't work in silos. All officers in the division, we should talk to each other. You work on an ad hoc committee like the league tape, which I worked on, very difficult. So if there's another committee coming, there's nothing wrong reaching out to your colleague. What did you do? What went well? What worked? What didn't work? So that we enrich ourselves and then proceed. On that note, I want to thank Dr. Dafoe for taking time to do a very, very comprehensive work. If you look at the presentation, it is 58-page slides, right? It is very detailed. We will share, and I think it can be a resource to all of us that would guide us to just keep on learning and getting very familiar with our standing orders. Mr. Minka, I want to say thank you for coming in and sharing your experiences with us, and then helping us know what works. Colleagues, I want to use the opportunity again to thank our Deputy Clerk who is here, that this is just the beginning. We have to make our parliamentary service what we want it to be. Tomorrow, we can point a finger to our children's children, that this is what we contributed. So the clarion call is here. Let's do more. Let's innovate. Let's put in our best, and then tomorrow we'll be happy with it. I thank you for your attention. Thank you.
Colleagues, you know what happened this morning wasn't good at all. Our members of parliament, especially Kojopo and Kromagoti at 8 o'clock, and the room was virtually empty. It doesn't speak well of us. I'm just appealing to all of you. This program is for us. It's for all of us to come and learn and also to share. It doesn't necessarily imply that the presenters and the panelists know it all. Sometimes the responses that come from you is what will help us to reform. So I'm pleading with you, tomorrow, don't let us have what we had this morning. Let's all try and be here as early as possible. The program starts at 9:30. We had to do that because we have to go to the chamber. It's almost 2 o'clock now, and you realize that most of the members are running to go back to the chamber. So please try. Tomorrow morning, let's all make sure that we start at 9:30. The exhibitions are ongoing at the foyer. From here, just go down there. There are certain things that you may think that you know, but in actual fact, maybe when you get there, I'm sure a lot of you only know about what happens when the bill is passed. What happens after the bill is passed before the president signs it? Probably most of you will not know, because it's something that happens behind the scene. And there are things that people like the legislation office will be telling you. So try and just get there. You see the infographics and then it helps you. So colleagues, try as much as possible so that tomorrow and probably the next one that we are going to have, we won't have the same kind of attendance. Thank you very much.
Thank you very much. It has been a very fruitful day, and I'd like to call on Ms. Benisewa Eduse to express our gratitude.
Thank you very much. As we all know, time is fast spent, so I'd like to sum this up. I would like to, first of all, thank the Almighty God on behalf of all of us that He made it possible, made the weather very clear for us to be able to come here. I'd like to also thank the presenters, most especially our Deputy Clerk, for the insightful presentation we had in the morning, and to Dr. Inestafo for the insightful presentation he also gave us this afternoon. I'd like to also thank the moderators, Honorable Pong Koma, Kujo Pong Koma, Mrs. Gifty Nuna Goba. Thank you very much, Madam. And to the panelists for sharing their knowledge and expertise with us. And to all of us here, I'd like to say thank you to all of you for making this session a wonderful one. Thank you for gracing this session with your presence. And to the committee, the organizing committee, I'd like to say thank you for working tirelessly to put all of this together for us. So like our Deputy Clerk said, tomorrow, I hope that we'll all be here very early to start the program on time. Thank you. God bless us.
Thank you very much. That will be it for day 2 of LMS celebration under the theme Strengthening Parliamentary Democracy, the Role of Practice and Procedure. May the LMS grow from strength to strength. No.